leveled against the Deputy President. Similarly, the Defense Council and the Deputy President of the Republic of Kenya will equally be accorded 60 minutes to convince senators, this being last-minute attempts to convince the House why the charges against the Deputy President should not be upheld and why the Deputy President of the Republic of Kenya ought to continue being in office. After the afternoon, allow me to hand you over for this live broadcast brought to you by the Parliamentary Broadcasting Unit in partnership with KBC. My name is Gladys Mungai. Enjoy your viewing.
Na tuombe. Mwenyezi Mungu, tutakusihi tutazame kwa neema nyingi na baraka sisi watumishi wako ambao umeridhika kutuita kwa nyadhifa za uongozi katika jamhuri hii yetu. Tutakuomba utuajalie tuyatende na kufikia mambo yote yatakayofikishwa mbele yetu kwa njia ya haki na uaminifu, ili kustawisha amani, ufanisi na heri ya nchi yetu na wale ambao haja zao umezikabidhi mikononi mwetu. Amen. Clerk, do you have quorum? Honorable Senators, please take your seats. We do have quorum, so we'll straight away go to this afternoon's business. Clerk, you may now call the first order.
Order number 1, communication from the chair. Order number 2, hearing and determination on the proposed removal from office by impeachment of His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya.
We'll give time to ample time to parties so that they can adequately present their cases. Now, as of yesterday, the Deputy President had allocated 3 hours. 1 hour was taken away for other businesses of yesterday and today. That is pursuant to a request by Counsel for the Deputy President. And therefore, as we speak, the Deputy President will have 2 hours to present his case, and thereafter the National Assembly will have 1.5 hours, because they've also consumed half an hour of the 2 hours that had been granted to them yesterday. So you had borrowed 10 minutes, you ended up consuming 20 more minutes. As per our record. Council, this is not a matter to debate.
Mr. Speaker, sir, I just wanted to clarify that we had borrowed 10 minutes.
Yes, you borrowed 10 minutes, but you ended up consuming 20 more.
No. We did get that indication, Mr. Speaker. In fact,
now you're getting the indication.
Yes. We had budgeted our time knowing that we had 1 hour, 50 minutes.
Consume the 1 hour and a half, and then let's see where that takes you, and I will be able to engage when you consume the 1.5 hours.
We are most obliged, Mr. Speaker, sir.
Thank you. Senior Counsel Paul Mwite, if you're ready, you may usher in your witness.
Mheshimiwa Speaker, just to get clarification, I was under the impression that the National Assembly will proceed and close their case, and that then counsel for the Deputy President will now present the Deputy President, who is the only one that we are calling as a witness. And that thereafter, the National Assembly will make their closing speech, and we will have the opportunity at that time to also make our closing speech. So I would like to
make closing remarks. Likewise, the team of the Deputy President will begin to make its closing remarks. Once that is done, the Senate will move into a closed session as per our rules of procedure. So that is the program for this afternoon.
I'm now very clear, Mheshimiwa Speaker, and I thank you. The situation is now clear. But just before my colleagues on the other side close their case, can I, through Mheshimiwa Speaker, ask whether the National Assembly still wishes to call a witness whose affidavit was filed, the governor of the county government of Nairobi, Johnson Sakaja. We have a copy of his affidavit. Is he going to be called or not called? Because if the National Assembly is not calling that affidavit, whose affidavit is part of the record and was availed to us, that affidavit, Mheshimiwa Speaker, contains allegations that are extremely injurious to the Deputy President. So if he is not going to be called, we will be making an application for that affidavit to be expunged from the records of this Honorable Senate. Thank you.
Counsel for the National Assembly, you had listed quite a number of witnesses. Are you going to call all of them, or are you going to, for the record, are you going to close your case where we are?
Mr. Speaker, sir, on behalf of the National Assembly, we shall close our case where we are. Mr. Speaker, sir, if you are, with your permission, I could respond to the submissions by my learned senior, Mr. Paul Mwite.
Please do.
Mr. Speaker, sir, at the beginning of the proceedings that we are currently going through, this House did invite parties to give indications as to the witnesses they wanted to call. Mr. Speaker, sir, we gave the list of the witnesses whom we thought were relevant for purposes of clarifying what we needed to have clarified. If counsel for His Excellency the Deputy President did not do as much or did not take advantage of that window that was open, surely they cannot blame us for it. But secondly, and more importantly, Mr. Speaker, sir, yesterday, in the course of the deliberations in relation to one of the preliminary questions that had been raised, you gave a very clear ruling on the intendment of Rule 20 of the rules of this House. In particular, the understanding was that every material that was forwarded by the Speaker of the National Assembly to this House constituted evidence in support of the allegations that are the subject of inquiry by this House. It then follows that if the application that learned senior counsel, Mr. Paul Mwita, is making were to be looked at in its totality, he is actually making an application to amend or to remove certain aspects of the evidence from the record. Mr. Speaker, sir, that is an issue that you settled and rested yesterday. I don't think it's an issue that is open for re-intervention. Mr. Speaker, sir, it should also suffice to note that even on our side, there are affidavits that form part of a record that came from the National Assembly. In particular, there is an affidavit sworn, and which is in favor of His Excellency the Deputy President, an affidavit sworn by the joint executors of the will, that is Mr. Njoroge Rigeru, together with the other executors. It is part of this record. We have not made an application to have it expand. We have an opportunity to deal with it when the time comes. Lastly, Mr. Speaker, sir, the nature of the sittings that this House currently is undertaking is quasi-judicial. It is inquisitorial in nature. If that is to be the correct position, Mr. Speaker, sir, then the rules of evidence as we know it in the court would not necessarily bind the proceedings, because what has been presented is the subject of what the honorable senators are going to investigate. At the end of it, it is not a judgment that they will be giving, it will be a vote. I rest my case, Mr. Speaker, sir.
Senior Counsel Paul Mwite. Yes, what is the point of procedure, Senator Boni?
Unprecedented, to the extent that when we stand down business in this House, it normally arises from a communication from the chair that you're temporarily, for a specific time, suspending the proceedings. You have not done this, and we are seated in the chamber. The mess is in place. I do not know whether we want this to be the new standard, Mr. Speaker. Could you guide us? We have no idea how long we're going to wait. And time is running, Mr. Speaker.
Honorable Senators, at the rise of the House at 1:15, I made it clear that upon resumption, the Deputy President was going to take the stand. We came in here, I communicated the program for the afternoon, and I said we're going to execute it with military precision, owing to the fact that we need to conclude business today. Senior Counsel Paul Mwite indicated that he cannot get hold of his client. That is not the concern of this House. So time is running. Order, order, honorable senators, order. The floor is available to the Deputy President and no other senator or no other enemy.
It is exactly 15:04 p.m. this afternoon, being the 17th day of October 2024. The afternoon sitting of the Senate this afternoon was to kick off with the Deputy President taking the stand, bearing in mind the DP, His Excellency Rigathi Gachagua, is the sole witness in the case where the National Assembly, through the move of the motion, Honorable Mwengi Mutuse has leveled 11 grounds for impeachment of the Deputy President from office. We have already dispensed with the prosecution side, and during this afternoon sitting, immediately after the commencement of business, the council representing the National Assembly have confirmed to the House that they do not intend to call more witnesses in regards to this case. The counsel for the Deputy President had requested the House through the Speaker that any evidence where the witnesses are not appearing be expunged from the record. It is a moment of waiting at the Senate this afternoon as the House awaits the arrival of the Deputy President, Rigathi Gachagua, who is set to take this stand at the Senate this afternoon and prosecute his case through himself as well as his defense and convince senators why the 11 grounds listed for impeachment should be quashed by the House. Our dear viewers, the motion for the removal by impeachment of His Excellency Rigathi Gachagua, EGH, the Deputy President of the Republic of Kenya, has 11 grounds where the National Assembly is seeking to have the Senate uphold the charges, or at least one of them, to have the Deputy President cease to hold office today. The mover of this motion has told senators for the better part of yesterday and today that his desire through this motion is that the House finds the Deputy President to have committed the offenses listed in this motion. And this afternoon, the defense of the Deputy President, led by Senior Counsel Lawyer Paul Muite, will water down those charges by the evidence that they will be presenting before the Senate this afternoon. And to just take you through probably some of the charges that the Deputy President will be seeking to counter this afternoon is charge number 1 on the gross violation of the Constitution and any other law. This is pursuant to Articles 150, subsection 1BI of the Constitution. Charge number 2 in the impeachment motion by Honorable Member for Kibwezi West. The Honorable Member alleges in his motion that there is gross violation of 147 subsection 1 and 152 subsection 1 of the Constitution, where the Deputy President is being accused of undermining the presidency. Under Article 147 subsection 1 of the Constitution, the Deputy President is the principal assistant of the President and shall deputize the President in the execution of President's function. In this motion, the Honorable Deputy President is accused of going in contravention with cabinet resolutions on matters evacuation of people residing along Nairobi River, and that shortly after His Excellency, shortly after being in contravention with the cabinet resolution, the Deputy President made public a statement opposing the Nairobi River riparian execution orders. According to the mover of the motion, this is undermining the resolutions by the cabinet. Under charge number 3, again on gross violation of Article 6, subsection 2, Articles 10, subsection 2A, Article 174, and Article 188, and the 4th schedule of the Constitution, where the Deputy President is accused of undermining devolution. The mover of the motion, in his motion, states that on the 20th of September 2024, His Excellency Rigathi Gachagua recklessly and calling and dignified status of the office of the Deputy President unlawfully interfered with the running of the Nairobi County government by holding a public rally in which he incited citizens against lawful directives by the Nairobi City County government on the planning and relocation of markets. This is just some of the grounds listed, or some of the annexes under charge number 3, where the Deputy President is set to defend himself on these charges, among others.
Senior Counsel Paul Muite. Your time started running.
Mheshimiwa Speaker, may I...
Let me just conclude, Senior. Your time started running at the time I requested you to usher in your witness. You indicated that you're getting hold of your witness. We'll give you all the time you need to get hold of your witness, but to let you know that the clock is running, and it's running on your client. You can take all the time, but his time is running out. After 2 hours, he's not appeared, the chair will make a ruling pursuant to the rules of procedure.
Mheshimiwa Speaker, may I start first and foremost by expressing apologies and regrets that the Deputy President is not here, and by not being here, the inconvenience and delay caused to Mheshimiwa Speaker and to honorable senators. The position, Mheshimiwa Speaker, is that during that period that I went to try to find out why he wasn't here, because as Mheshimiwa Speaker knows, the Deputy President has been coming here absolutely punctually every day. The sad reality is that the Deputy President of the Republic of Kenya has been taken sick, very sick, and as I address Mr. Speaker in this honorable House, senators, he is in hospital, Mheshimiwa Speaker. That is a sad reality.
For the Deputy President, considering that this is a time-bound process, what is your reaction?
Mr. Speaker, sir, this is a house governed by the rule of law. We truly empathize with the difficulty that His Excellency, the Deputy President, has found himself in. But, Mr. Speaker, sir, pursuant to Rule 11 of the rules governing this process, if I may, with your permission,
maybe Counsel for the National Assembly.
Yes, Mr. Speaker, sir.
Just take a seat before you make your rejoinder. Senior Counsel Paul Mwite, having said whatever you've said, what is your proposed way forward so that a reaction can be put from the National Assembly? Are you telling us we wait until your client gets here? What is your proposed way forward?
Mheshimiwa Speaker, I have just received this information. My proposal is that you give me at least the rest of the day. I would like to go and have an assessment of his situation and maybe even come back here by 5 p.m. Right now, I would like to make an informed sort of situation after I see the Deputy President and I see the doctor, Mheshimiwa Speaker, at least an hour or two. Yes, thank you.
Very well. Counsel for the National Assembly.
Mr. Speaker, sir, having very keenly listened to my learned senior colleague, Paul Mwite, Senior Counsel, it puts us in a bit of a difficulty because whereas we may want to empathize with the situation, there appears to be no indication from their end as to a specific proposal. Mr. Speaker, sir, this being a house governed by rules, and this process being a time-bound process, I will draw your attention to Rule 11 of the rules of this House. If I may read Mr. Speaker, sir, that where the National Assembly or the President chooses not to appear before the Senate, that fact shall be put on record and the Senate shall proceed with its investigation without further reference to the National Assembly or the President. But the Senate may, for exceptional reasons to be recorded, permit a later appearance before the Senate by the National Assembly or the President. Mr. Speaker, sir, I think this rule would give us guidance. We may proceed. If it becomes necessary, then any additional material may then be availed. This is a time-bound constitutional process, Mr. Speaker, sir. I'm most obliged.
Let me pick the wisdom of my wonderful senators before I make my decision on the way forward. Now, I understand that all of you are wise men and women.
Speaker, can I just say a word?
Yes.
I've heard what Senior Counsel Paul Mwite has said. And, Mr. Speaker, you have made it quite clear that these proceedings are time-bound. It's not so much about the situation in which His Excellency the Vice President finds himself. It's about the Senate complying with the provisions of the Constitution. That within that time frame, you must make a decision. Reading the standing orders that my learned friend, Mr. Rick Gumbo, has referred to, it would be helpful to this House if Senior Counsel Paul Mwite could probably give us a way forward in terms of the time limitation that the Senate has. I'm saying this because we don't want somebody to say that the Deputy President was not given an opportunity to be heard. I think the Senate will want him to be heard. But knowing the time limitation, what suggestions does the Senior Counsel have to ensure that we keep within the time parameters? At the same time, the Deputy President is given his space to defend himself.
So we have two sides. We have the minority side and the majority side. I will only allow the two leaders to speak. If you need to consult in the next 1 minute, now, honorable senators, our standing orders have not been suspended yet. It is only Senator Mazayo and the majority leader who, the rest, take your seat. The rest, please take your seat. Order, honorable senators. Honorable senators, we are facing a very unprecedented situation. At the rise of this House at 1:15, I indicated that upon resumption, we were going to hear the Deputy President. Upon resumption, Senior Counsel Paul Mwite, for and on behalf of the Deputy President, when I asked him to usher in the Deputy President for purposes of presenting him to give his evidence in chief, the Senior Counsel indicated that even him, he was unaware of the whereabouts of his client, and he asked for a few minutes to go fetch him wherever he was. After a few minutes, Senior Counsel Paul Mwite came back to the chamber and indicated that he had gotten information which he was yet to verify, that his client had fallen sick, and indicated that he needed time to go look for him in whichever hospital he is, and that he should be given up to 5 p.m. today. The Counsel for the National Assembly, in response, indicated that this is a time-bound process. He referred to the Senate to Rule 11 of our rules of procedure that where the Deputy President fails to appear, the Senate can actually proceed, or for exceptional reasons to be recorded, permit a later appearance before the Senate of the Deputy President. Having considered the two sides, my directions are as follows: that we will suspend this sitting and resume at exactly 5. So the Deputy President, we expect the Deputy President then to take the witness stand at 5. This is a time-bound process, unfortunately. It is so ordered.
The Speaker of the Senate has directed that the sitting be adjourned for about a couple of hours for the Deputy President to get hold of him. As it is, our dear viewers, at this particular juncture, the lead counsel for the Deputy President has just told the House that they could not get hold of their client, requesting for more time to get in touch with the client. Senior counsel lawyer Paul Moite has told the House the information he has is that the Deputy President has been taken ill. And so for this juncture, we will be taking you back to the broadcasting house KBC. We will be resuming these normal proceedings. We will be resuming these normal proceedings again at 5 p.m. My name is Gladys Mungai, and on behalf of the broadcasting team that made this possible, we will be back with this live broadcast at 5 p.m. this evening.